Hi, guys. I hope you can hear me now. I am just testing the audio and I see the light is flickering. So if you can't hear me, if you can hear me, leave a comment in the chat. Just say you can hear me, please. The last stream I did, apparently no one could hear me. You would not believe the technology issues I've been having lately. So it's Christine here again. Thank you. Thank you, Indy, for letting me know that you can hear me. So it's Christine again from the Canadian Constitution Foundation. And as promised, I'm going to tell you everything that happened at the hearing yesterday at Divisional Court in Toronto in the legal battle over freedom of expression between Dr. Jordan Peterson and the College of Psychologists of Ontario. I'm sorry about the earlier technology problem where you couldn't hear the audio and the video. And I'm sorry I didn't get to do the live stream after court yesterday. When I got home, the power in my whole neighborhood was out. I just have been having terrible luck with all types of technology related issues. So hopefully that curse is over now. So let's get to what happened in court yesterday. I'm going to describe the arguments that were made by all sides. So as I'm describing it, remember that I'm just describing what was argued. I'm not giving you my opinion about the arguments. I'm just explaining what happened, unless I expressly tell you I'm giving you my opinion about something or describing what we argued, which I obviously agree with. Also, I'm not giving you verbatim quotes. What I'm telling you is just based on my notes, so it might not be exact or precise. So to remind everyone what this case is all about, it involves Dr. Jordan Peterson, who is a clinical psychologist. This is of great importance that he is a clinical psychologist, and also a media personality who comments on social and political issues, an author, public speaker. So he had made some public statements on social media, on Twitter in particular, and on YouTube, and on the Joe Rogan podcast. And members of the public made complaints about some of those comments, mostly informally. The complaints were mostly made informally by tagging the College of Psychologists on Twitter. But two complaints were made formally in writing through a process that the college has. Now, none of the complaints that were made were by current or former clients or patients of Dr. Peterson's, or indeed by anyone who had any personal or professional relationship with him. In response to these complaints, the college started an investigation and they found that Dr. Peterson's comments posed what they described as a moderate risk to the public. And they ordered that Dr. Peterson do some training on professionalism in public statements. So, to clarify, this was not a finding of misconduct, but a finding of what they described as concern. And the training that they ordered would be at Dr. Peterson's own cost, and it would continue until the coach who was proposed by the college was satisfied. And if they were not satisfied, the college could proceed to discipline and they have a range of options. They could do nothing, or they could remove his license to practice as a clinical psychologist. And keep in mind, he's actually not even currently practicing as a clinical psychologist, and he was not practicing when he made these comments. So, we're going to get into some detail about the comments themselves, what triggered all of this, but let me tell you what they were. So there were a bunch of them that triggered these complaints. There was a comment he made on the Joe Rogan podcast about, to quote, poor children. Joe Rogan and Dr. Peterson were discussing economic development, climate change, and deaths from air quality, air pollution. And Dr. Peterson said, oh, well, those are just poor children dying. And Joe Rogan said, I mean, you're being facetious, right? And he said, yes, I'm being facetious. The point of the exchange was for Dr. Peterson to point out the hypocrisy of certain people calling for climate policies in the West that limit economic development at the expense of the developing world, and that those people who are making these calls don't actually care about the suffering of poor children. He was not celebrating the death of poor children. He was pointing to the hypocrisy of Western activists who actually claim to be doing things to help poor children, but are actually hurting them. So The next comment that was of concern to the people who made complaints and to the college was about the transgender actor Elliot Page, or Ellen Page, as this actor was formerly known. Dr. Peterson had retweeted a post about a character that Elliot Page plays on a television show. And a quote, I think it was something like Page said she was proud, or he was proud to be a trans actor, or something like that. And Peterson retweeted that with a comment along the lines of pride is a sin, and a quote, criminal doctor removed Ellen Page's breasts. Ellen being Page's former name before a gender transition. This is something called dead naming. And at the time, Twitter had a policy against dead naming, and this tweet resulted in Peterson's account being suspended. So that was another comment. Another comment or a series of comments that resulted in a complaint was a back and forth with two Canadian politicians or political operatives in an exchange with Justin Trudeau's former chief of staff, a man named Jerry Butts. Peterson called Butts a prick. And in an exchange, and this had been part of a lengthy and heated exchange. And in another exchange with a non-binary Ottawa city councillor named Catherine McKenney about the Freedom Convoy, Peterson called McKenney an appalling, self-righteous, moralizing thing. And that seems to have attracted attention because of perhaps the term thing in particular, and the fact that McKenney uses they, them pronouns. So that was one group of comments. Another comment was another Joe Rogan comment. Peterson, when he was on Rogan, was discussing what was a tumultuous time in his life when a lot of pretty bad things were happening and he was under a lot of strain. And I think this was also around the time where he was having medical problems related to these addictive pills that led to a lengthy treatment and some very serious medical problems that arose out of this. So as a result of this tumultuous time and these medical problems, Dr. Peterson was describing how he needed to cut back on seeing clients because he had an active clinical practice at the time. And he described how one client was very upset about this. She had come to rely on their counseling sessions, and she was angry that they were being cut short. So Peterson describes that she came after him with a pack of lies. She was a vindictive former client who came after him with a pack of lies. Those are his words, and alleged some form of sexual misconduct on Dr. Peterson's part. That's what he said about it, and that is what triggered the complaint. But it's also important to know that the college received that complaint, the sexual misconduct complaint. They investigated it, and it was found to be unfounded. So he was exonerated. These were lies. But him talking about that on the Rogan podcast led to this new investigation about him complaining about this former client, complaining about him. The last comment that's relevant for this hearing was about a plus-size model who was featured on a cover of a Sports Illustrated swimsuit magazine edition. Rogan either retweeted or posted the picture of the cover and said something along the lines of this plus-size model, sorry, not beautiful, and no amount of authoritarian tolerance will make it otherwise or make me believe otherwise, something like that. So those are the comments. Some of them are pretty, a little mean. You could maybe say I wouldn't say that. I don't think I would say a lot of those things, but they resulted in the college conducting an investigation into Peterson, and that investigation led to that order for professionalism training and public statements. And the hearing that happened yesterday was a judicial review of the college's decision to order that training. So I got to court yesterday early at Old Osgood Hall, which is the big courthouse in downtown Toronto. The hearing was scheduled for 10 a.m., so I arrived at around 9 to make sure I had a seat. There were a lot of lawyers present, maybe 15 to 20 gowned lawyers. And the courtroom holds maybe 40 to 45 people. So half of the room was already full of lawyers before there was room for anyone in the gallery. I mentioned in my last video that there had been requests for a Zoom link from the court so that the public could watch, because I know a lot of you wanted to watch it. And that request was denied by the court. And I got a lot of questions from viewers of this channel about why that request was denied. So I was asking, while I was waiting for an hour to be let in, why that was denied. And, the court doesn't give reasons for why a request like that is denied. But speaking to some of the lawyers who appear regularly in front of divisional court, they said that technology at this court is regularly a problem, and that they don't actually recall there being any what are called hybrid proceedings. That's where part of the proceeding is online and part is in person. The divisional court, they said, it seems to always be all in person or all online. So I get the sense that the divisional court just isn't equipped to do Zoom links for the public, even though the Court of Appeal does it all the time, and they're in the same building and uses, in fact, the exact same courtrooms. So I don't know if that answer is satisfying, but that's what I was told. So it took a while to get in to the room. There was a pretty big crowd by the time they opened the door. I was able to enter with our lawyers, so I did get a good seat. And I'm also actually a member of the media because I host a national broadcast television program called Canadian Justice. So I got a seat at the media table that was otherwise empty, and I was able to do live tweeting. You can go to my Twitter account at @CVanGuyen to read all of those tweets as they happened. So the rooms are really beautiful. It's a historic courtroom with this mosaic tile floors, a big atrium, beautiful statues. Our courtroom had these, hundreds of rosettes in the ceiling with multiple cornices. But the downside of these historic rooms is that the benches are super uncomfortable and there are no electrical outlets. So that was a challenge for everybody. While we were waiting, there was a lot of discussion about whether or not Jordan Peterson himself would actually show up. He's not required to attend. His lawyer can appear without him. Ultimately, he didn't come, which was probably disappointing for some people. There were a lot of members of the public. I don't know if they were supporters or detractors of Dr. Peterson, but there was obviously a lot of interest in the issue. And him being there in person probably would have been exciting for a lot of people in the gallery. I mean, I would have liked to see him, but he didn't end up showing up. So the panel for the divisional court hearing was 3 justices: Justice Backhouse, Justice Shabbos, and Justice Kroshenko. Now, I know just a little bit about some of these justices. Justice Backhouse wrote the decision in another case that we are seeking to intervene in, a case called Petrucci that case struck down an unconstitutional math test for Ontario teacher candidates because the court found that this math test was discriminatory. We are seeking to intervene in the appeal of that decision because I don't think that math is discriminatory. The other judge, Justice Shabbos, I know that he used to be in private practice at a large national law firm called Blake's, and his practice was in media and constitutional law. So he has a lot of expertise in issues related to freedom of expression. He was also the most verbally engaged judge on the panel. He had well and above the most questions. And the only thing I know about Justice Kroshenko is that he's based in Hamilton. I don't know much else. So in terms of the parties and the lawyers, Dr. Peterson is the applicant in this case. He's the one seeking the judicial review, and his lawyers are from a high-profile boutique firm called Hennon Hutchinson. The College of Psychologists were the respondent. They were the ones sort of defending this decision, and their lawyers are from a large national law firm called McCarthy Tétrault. So the advocacy on all levels we knew was going to be really high. There were 3 interveners in support of Dr. Peterson's position and 2 in support of the college. In support of Dr. Peterson was us, this Canadian Constitution Foundation, and we were represented by lawyers from an international law firm called Baker McKenzie. The Canadian Civil Liberties Association was represented by a national law firm called BLG, and there's a newish organization called the Association of Aggrieved Professionals, and they were represented by a lawyer from a boutique health law firm. That's a group made up of members of other regulated professions who have concerns over professional discipline. So they come from professions like healthcare, law, engineering, accounting, teaching, things like that. And in support of the College of Psychologists was another regulator, the College of Physicians, and they regulate doctors and obviously have an interest in maintaining and maybe expanding the scope of their regulatory power. There was also a joint intervener for gay and trans rights, the groups Egal and Trans Justice. So a lot of people in a very small and warm room. When the panel of judges came in, they started by commenting on the unusually full courtroom. And we started off on a preliminary issue before getting to the merits. The preliminary matter was that the College of Psychologists, now I haven't talked about this before, but they were seeking a publication ban related to the names of certain individuals in the case. And they explained why. I'll summarize it because I don't think I've talked about this on the channel before. Basically, what had happened is when this whole dispute between the college and Dr. Peterson started, there was this report from the college given to Dr. Peterson. And the report included the names of some staff members of the college and two of the coaches that the college was proposing would coach Dr. Peterson in his professionalism training. So Dr. Peterson tweeted out a copy of this report, and it had actually redacted the names of these people, but apparently the redactions were not, there's this way of getting around them. So some very ambitious members of the public, I guess, removed the redactions somehow and found out the names of these staff members and coaches and then started emailing them. And some of these emails apparently were not so nice. And according to the college, some of the emails were threatening. So after this happened, it's not good. That's not good. That's not good to send threatening emails. Is bad. You should obviously not do that. So what the college did was they sought a sealing order on this document, but the college was arguing yesterday that that sealing order doesn't protect these individuals' names because they're still, out there on the internet. Now, Justice Shabbos asked the college if they were in effect asking for Dr. Peterson to take down that tweet, which had this document in it, and that was posted before that sealing order was made. He said, Dr. Peterson has not named the coaches and the college staff since. And the college said, yeah, we are basically asking for him to take it down. They said their concern is also for the future that people will continue to harass these coaches. And he said, in the world of newspaper, newspapers don't have to take back a hard copy, but this is virtual, and so we can take it back. Now, Professor Justice Shabbos, who is practiced in media law and private practice, he said newspapers resist this in the digital context. They don't want to take things down that have already been published. So it was also agreed that the sealing order should continue. And Dr. Peterson was opposing this publication ban. His lawyer, a man named Peter Hennon, he argued that the college is basically seeking a retroactive publication ban and that this motion for a publication ban should be dismissed, that the order would be unenforceable, that the idea that people will continue to be harassed is speculative. There's no evidence that people have been identified since the original sealing order, or that Dr. Peterson in any way deliberately breaches court orders. And Peterson's lawyer cited some case law for the principle that courts should not make orders that can't be enforced, and information just can't be taken off the internet. And the tweet has already been viewed over 1 million times. So the judges went away, and then they came back and they agreed. They said no publication ban. The sealing order would continue. That was already in place, but a publication ban would be retroactive and unenforceable. So we started the day with, I guess, a small initial win for Dr. Peterson. We then turned to the merits of the case, starting with Dr. Peterson's lawyer, again, Peter Hennon. And he started off by saying, since 2017, Dr. Jordan Peterson has not had a clinical practice, and he's seeking a judicial review of the College Investigation Committee. This is called the ICRC, and their decision in 2022 that looked into these complaints about his public statements and found this, quote, moderate risk to the public, and ordered Dr. Peterson to do professionalism and public statements training. And Mr. Hennon argued that the failure for Peterson to do this could lead to the loss of his license. And Peter wanted to start by making two initial arguments for his client, Jordan Peterson. First, that the ICRC, this College Investigation Committee, failed to do what is called the Doré proportionality analysis. They failed to do a proportionate balancing with Peterson's right to his charter protected right to freedom of expression and the mandate of the college to monitor and regulate the profession. His second argument was that they failed what's called the Vavilov analysis, which requires that reasons be intelligible and transparency, basically that the reasons they gave for ordering this training were kind of circular and self-serving, and that they didn't give enough of an explanation about why this was needed. And Mr. Hennon, for Dr. Peterson, wanted to emphasize the court's not being asked to endorse any of Dr. Peterson's statements, but rather to hold the College of Psychologists to the standards of administrative law, those Doré and Vavilov standards. Now, I won't go too much into detail about those things. Vavilov and Doré is complex administrative law. It's difficult for a lot of lawyers, so I won't get into it in much detail, but basically it means decision makers like tribunals or the college in this case, they have to show their work. And Peterson's lawyer argued that the decision ordering the training didn't balance his right to freedom of expression, and it didn't give any reasons. It was just kind of conclusory. It didn't explain why they reached the conclusion they did. Peterson's lawyer also argued that if there's this fundamental gap in the reasoning given by the college for ordering this training, it's not the role of the court here in the hearing yesterday to fill that gap by going back and what he called mining the record. That means if the decision by the college to order this training didn't have enough reasons, if it wasn't reasoned, intelligible, transparent, the court now can't go back and fill in the reasons for the college. The college needed to do their job, and if they didn't, the order for training should be quashed. So then the lawyer, Hennon, for Jordan Peterson, turned to the ICRC decision itself. This was the college's investigative committee decision that ordered the training. He said that that decision found there were two kinds of risks, this moderate risk from Dr. Peterson's tweets and public statements. There were what were called impact risks, which is the ability to impact the public. And then there were what were called recurrence risks, the risk that Peterson will do these things again, make these comments again. And then the decision, the ICRC decision, goes through the different complaints. And Mr. Hennon said the complaints, all but two, were just tweeted at the college. They were made really casually. Basically, people tagged the College of Psychologists in tweets. And that was what happened. That's how the investigation was launched. And there were two complaints that were formally submitted in these report forms that the college has. But under personal information, the reports claimed to be Peterson's clients. And this was false. They were not clients. So in spite of all of this, the college started this investigation. They appointed an investigator, and then they identified the comments of concerns. And as I told you at the beginning, the tweets in basically the things that the college was concerned with were Peterson calling himself a clinical psychologist, which he is, but he was identifying himself in his Twitter bio and in the Joe Rogan podcast when speaking. He called himself a clinical psychologist. Then he made these jokes about poor children, which actually were jokes about the left not caring about poor children. He described this so-called vindictive former client. He made a tweet about a transgender actor. He got in arguments with political operatives and politicians, and he made comments about aesthetic beauty standards and a particular model. Now, each of these tweets, Hennon argued, involved Dr. Peterson engaging in some political debate or commentary on social or political issues. And the panel, the ICRC, the college investigative panel, They found that those comments, the conduct they called it, posed a moderate risk to the public. And they briefly mentioned that Dr. Peterson, in responding to their initial inquiry, said that his speech is protected by the charter and it's unrelated to the practice of psychology. That's what Peterson told them in response. But then they have one sentence on the charter. They recognize a right to freedom of expression, and then also said he has an obligation to maintain the standards of the college, of the profession. And this was the sole analytical consideration of the charter in the college's decision. So here, Justice Shabbos asked a question of Dr. Peterson's lawyer. He says, well, what more should the college investigative panel have done? They recognized his right and they also recognized his professional obligations. What more should they have done to meet that Vavilov requirement to give reasons? And in response, Peterson's counsel, his lawyer, Peter Hennon, cited a new decision from the Ontario Court of Appeal called Lozon. And he said that the college made no mention of the chilling effect or the deleterious effect on the decision, which was an issue in Lozon. And they recognized that he had a right to expression, and then they just ignored it. And the college decision, Mr. Hennon said, did discuss the impact on the public to some degree, but it engaged in no balancing. They just said, these comments are going to hurt the public, and that's it. And Peterson's lawyer said it's not enough to just say it. Vavilov and Dore, these administrative law standards, require the panel, the college, to show their work and do some proportionality analysis. The decision from the college, the ICRC panel, said that they were also concerned that the type of risks his comments posed, that Dr. Peterson's comments posed, were things like undermining public trust in psychology, undermining the trust that the college can self-regulate, and undermining trust in Peterson's own ability as a clinical psychologist. But to do that part of the analysis, they also need to do balancing. And even on a close reading and generous reading of the analysis that the college did here, Peterson's lawyer argued that it was lacking. Now, on collateral effects, on the harm that they could have gone into, Peterson's lawyer argued there's obvious chilling effect on any regulated professional other than Dr. Peterson, who has millions of followers, is famous and wealthy. So this creates a chilling effect on people who might not have the resources to challenge the college, might have greater fear of the college's sanctions against them, might not have their ability to support themselves if their college comes after them for comments that they made online outside the scope of their actual work and remove their license. So at this point, Justice Shabbos had a question. He said, the panel, the ICRC, the college investigation panel, they didn't make a finding that what he did was unprofessional. They did not impose a restriction on his speech. This is just what he describes as remedial. This isn't a disciplinary decision or a finding of misconduct at this stage. There isn't a ban. There is some impact, Justice Shabbos said, but how significant is it? So remember, he's been ordered to do media retraining. So Peter Hennon, this is Dr. Peterson's lawyer, he answered and he said, if you turn to the language, it actually, of the order from the college, it actually does limit his expression. And he pulled it up and it says, Dr. Peterson shall enter a coaching program to review, reflect on, and ameliorate his public statements. So what does ameliorate mean? To improve, make better, or change. They are seeking to change his expression. And Hennon went on to say that the right to freedom of expression is broad. It includes tone. And he said there's more. If a coach provides unfavorable feedback to the college can investigate further. And this coach has control over that whole process. The college has deferred to the proposed coach. So Justice Shabbos asked a question again. He said, all this coach does is give feedback to the college and say, how is it going? How are things going? Is he doing this work? And Hennon answered, no, the coach has significant discretion. If the coach doesn't think that they're satisfied, the college can investigate. It's the coach who decides if Peterson has ameliorated, if he has changed. So Chavez asked again, but the coach makes that decision, but the college may get that report and just leave it. They may not do anything if the coach isn't satisfied. And Hennon answered that ultimately the coach does have this role to judge whether Peterson has sufficiently completed the program, which requires him to accept what the coach is teaching him. For this, he cited some very famous freedom of expression case law, cases like Irwin, Toy, Keegstra, and Zundel. And he said that the scope of protected speech is very broad. This is all old and important Supreme Court case law. And the scope of freedom of expression includes offensive speech, minority views, and exactly the type of speech at issue here. Given the importance that the Supreme Court of Canada has placed on freedom of expression and the fact that this college investigative panel that ordered retraining did no analysis of the right to freedom of expression, Hennon argues that the order fails on Vavilov and Doré on that analysis and requirement to give reasons. So Peterson's lawyer then argued that the college decision to order this retraining is also inconsistent with a prior decision about Peterson from 2020. This was a college decision. This involved an investigation into public statements Peterson had made about general issues related to transgenderism. It was not related to specific people. And Hennon said the content of that decision is somewhat relevant, though different. And in that decision, the panel found Dr. Peterson's statements did not relate to public trust, though they said they could be seen as transphobic by some. It's a matter of opinion and debate. And as long as it's not violating any federal or provincial laws, they aren't going to order anything. So if you made those statements in 2020 that resulted in no discipline, why would this decision result in this raising of concerns and the ordering for training? So that was it for Peterson's lawyer, Hennon. Next up, he had a second lawyer, another lawyer named Matt Gourlay, who is a criminal defense lawyer by training. And Gourlay followed up on Justice Chavez's questions about the role of this coach who was the college was going to make Peterson hire at his own expense for an indeterminate amount of time. And Gourlay said that the act of misconduct is complete if the coach says Peterson didn't complete the retraining. So the role of the coach is actually very significant. It's up to the college to prosecute. But if the coach says Peterson didn't do the training, that is fine. That is the misconduct. So to analogize, he said, whether a criminal offense is committed is not up to whether or not the Crown prosecutes. So on whether this preliminary, on that other question of whether this is preliminary or remedial, whether this is actually not discipline, Gourlay turned the court to another decision from earlier this month, a recent decision, a case called the Law Society of Newfoundland and Buckingham. And that case involved a criminal defense lawyer whose client died in custody. So this lawyer was obviously upset that his client died while he was in police custody. And he put out a public statement about the death of his client. And the union, I think it was the police union or it was the prison guard union, I forget which one, they did not like this statement that this lawyer made. This lawyer whose client had been killed, had died. They did not like his statement, and they issued a complaint against this criminal defense lawyer. And in response, the Law Society issued a caution against the lawyer. The lawyer did not like being cautioned, so he sought a judicial review of the caution. So very analogous here. This was not the final discipline against the lawyer, just as this is not a final discipline against Dr. Peterson. It's sort of a preliminary stage, you could say. The Law Society in Buckingham said exactly that this is preliminary or remedial, and as a result of it being preliminary, a full Doré analysis isn't necessary. And That the Court of Appeal rejected that. They said that the real impact of this even though it was a lesser form of sanction, it was not a finding of misconduct, but it still has a real effect on a professional. They have been called out, they have been impugned, and a lesser disposition still has actually ends the process. The professional gets tarred with the suggestion of unprofessionalism without a full process where he or she can defend himself. And like the caution in that Buckingham case, this professional training in the Peterson case is a final disposition of a sort. And Peterson, Gourlay argues, is entitled to what Lozon and Doré and these other cases say they're entitled to when a charter right is engaged, which is a consideration of that charter right. And Gourlay said it's actually only a small number of cases that are going for a regulator that are actually going to engage charter rights. Most regulator cases are kind of mundane. They're things like discipline over record keeping or the actual practice of clinical work or lawyering. They're not about speech for the most time. So then Gourlay, Peterson's second lawyer, turned to his main submissions and he made 3 points on the distinction between off-duty conduct, so Peterson's private speech, and clinical conduct, which is practicing psychology. Gourlay said regulators need to tread really lightly when rights are engaged. Then he addressed something called the Groya case, which is a professionalism case about an Ontario lawyer that he said is not relevant here. I'm not going to get into that. And then he said that then his third issue was that the specific comments in this case, the panel's analysis failed to give reasons. They failed the reasonableness requirement under that Vavilov test. So on the issue of off-duty conduct, Peterson's lawyer, Gourlay, said it's not just the fact that this whole case deals with expression. Regulators can regulate expression that relates to practitioners' work. For example, relationships with clients, advertising, things like that. And regulators can even go outside the so-called four corners of the profession sometimes, for example, to protect the integrity of the profession. But when doing so, they need to tread carefully. And when it comes to what Gourlay describes as the ethereal idea of conduct unbecoming or that tarnishes the repute of the profession, he said there's a risk that that type of regulation will tread into overreach. And he said there's obvious problems of fair notice as well. Often these things about what is conduct unbecoming or what will tarnish repute, that's often in the eye of the beholder. And if you don't know if something is going to tarnish the repute of the profession or be conduct unbecoming, you never know if you're going to cross that line. So Gourlay said most often these conduct unbecoming things don't even engage freedom of expression issues. They usually actually deal with things that are just straight up criminal. For example, he gave a case involving a dentist who was convicted of sexual assault, not against a client, but he said that having a dentist who has a sexual assault conviction against them, that can bring the profession into disrepute. And he said it's very telling that almost all the cases that the college relies on are about criminal or quasi-criminal behavior, domestic assault, sexual assault, harassment, and these don't engage charter rights. There's no charter right to commit an offense, to commit a criminal offense. Whereas this case involves just speech that some people object to, but speech. And to find a case that analogized to what happened to Dr. Peterson, Gourlay, his lawyer, points to a case called Strom and the Saskatchewan Nurses Association, or Saskatchewan Nurses. And this was actually a case that we at the Canadian Constitution Foundation were involved in. In Strom, a nurse named Carolyn Strom complained on Facebook about the care that her grandfather had received at a long-term care facility, saying that she didn't like the care that he received. It was inadequate. And as a result of those posts, she was subject to professional discipline from the nurses regulator. The discipline was overturned on appeal, and the court on appeal found that the regulator had waded too far into the off-duty conduct of one of its members, of this nurse, where that conduct was objectively fine. It was not improper. So he said that that case is much more analogous to what happened with Peterson, as opposed to these cases of rapist dentists. This is not about any criminal activity. This is about speech. It's a lot more like the Strom case. Then Gourlay compared another case, which was a case from the physician regulator called Rath, and that case involved a physician who, I guess, freaked out at a kid's concert, and he was angry and yelling at people and saying terrible things, apparently. And he did get subject to discipline. And Gourlay said that that case, the Rath case, is notable and stands out because it was so close to the line and it generated a dissent. The majority in the Rath case said they're not dealing with speech protected by the charter, nor is it a case of a professional being disciplined for private conduct. They called it a verbal assault in a public setting with children present. And that's what they said. The court in Rath said generated this finding of misconduct. But the dissent disagreed. And the dissent said there must be some boundary of discipline that physician, there must be some boundary that the discipline committee cannot just go after physicians when they are removed from their professional activities. And the dissent said, Rath's behavior of yelling and being angry at this kid's concert, they said it was rude and confrontational and inappropriate, but they said we don't discipline people professionally for this. Chavez then interjected to say here, Dr. Peterson did make a point of saying he was a clinical psychologist when he was, maybe not when he was making all of these statements, but he had it in his Twitter bio. He was introduced on the Rogan podcast with that qualification. And Justice Chavez said, presumably that was to lend weight by virtue of his qualification. And Gourlay replied to say that this must be seen in the context and the reality of the case. And the reality is that Dr. Peterson rose to prominence from his position as a clinical psychologist. It is no secret to anyone who's encountered his work that he is a clinical psychologist, and it would strain credulity to think people don't know. So the point of putting it in there it doesn't matter. Everyone already knows. So Chavez then asked, so why does Peterson say it at all? In Rath, this doctor got mad at a kid's concert, and when talking about off-duty, these cases aren't dealing with someone who is making these statements that are objectionable and then citing their profession. And Gourlay said he doesn't agree that the majority of Peterson's comments mention his status as a clinical psychologist. Sometimes they do, but this standard that it was in his Twitter bio and people always know that he's a clinical psychologist. It means effectively there is never off duty. He can't run away from his status, even if he doesn't include it. Everyone already knows. And the College of Psychologists, their committee that ordered this retraining, they made a really big deal about the fact that he said it. But the truth is everybody already knows. And his comments don't actually rely on his status. He doesn't say, as a clinical psychologist, I think Jerry Butts is an X or whatever he said, a prick. Or as a clinical psychologist, I think that this model is not beautiful. He doesn't say that. He's not relying on his status to make these statements. So Chavez said, well, are you having it both ways here? Dr. Peterson owes his fame to being a clinical psychologist, but then you're also saying he can't run away from it. And Gourlay responded by saying, the Rath case, this physician who yelled at the kids' concert, Rath isn't a famous person. And Dr. Peterson is. But that doesn't detract from his right to express himself. If he's dispensing clinical advice, it's relevant. But if he says, I'm a clinical psychologist and this is what I think of the trucker convoy, that's not doing anything for the public. That's not at all related to his profession. No reasonable member of the public would think when he makes comments about, for example, the trucker convoy, that he's making it those comments standing in the shoes of a clinical psychologist. So Shabbos says, then asks, Justice Shabbos says, well, what about when he uses that language that the college has described as degrading and demeaning? And to answer that, Peterson's lawyer takes us to the college's decision. And let me just have a sip of water. Hold on. So the college noted that on Joe Rogan, Peterson is introduced as a clinical psychologist. And he says in the course of the interview that he's a clinical psychologist. His Twitter bio says it. And then the college decision looks at the comments about, poor children and the former client that Peterson called vindictive. And Gourlay says that these comments need unpacking. And we've already talked about this a little bit. On the vindictive former client, ultimately the college decided there was no basis to proceed on that complaint. So what was the point of this? Like, is he not permitted to speak about the fact that there was a complaint, an unfounded complaint made against him? There's no principle of law that stands for that proposition. The way they described that the problem with that is they just announced a conclusion that it was disparaging to talk about that this had happened to him, and they just affixed the adjectives of degrading and demeaning to it. They said they were just concerned about him making these comments about a former client and about, these poor children comments. Those are just terms that they gathered up from the code of ethics. All they did was reiterate the comment and announce that they fit the bill of the code of ethics. They didn't mention the fact that the vindictive former client complaint was found to be unfounded, or that the complaint was false, or that the comment about poor children was facetious and meant in defense of poor children and as a criticism of progressive politics. Is the college saying it's degrading to say that you were falsely accused of something and to be unhappy about it? Or is the college saying it's degrading to criticize the politics of hypocrisy of progressives who claim to care about the poor, but actually turn their faces away from policies that they promote that lead to the death of poor children? Of course not. This is absurd. On all of this, I think that there was a lack of, in my opinion, good faith, both in the complaints and in the way the college treated the complaint. But that's my opinion there. So Gourlay, on the issue of the poor children, he gave an example of this famous book by Jonathan Swift, A Modest Proposal, and it was about solving a famine by eating Irish babies. And obviously, this book is quite famous for being a facetious book about hypocrisy of certain types of politics. It's not a literal policy proposal. So Gourlay says all of these comments by Peterson are comments on social and political questions, and that goes to the core of freedom of expression. He says these are questions that the panel at the college who did the investigation needed to ask and did not. He then turned to some of the other comments that were made, the comments about this Ottawa City Councillor, Catherine McKenney, who Peterson had called a self-righteous moralizing thing or something like that. And about the actor Elliot Page, who he said pride is a sin, and used Page's former name before gender reassignment or affirming surgery, and also said that her doctor who removed, or his doctor who removed his breasts was, to quote Peterson, criminal. So in response to, in describing how the college went through those comments, Gourlay, Peterson's lawyer, said basically what the college did was they gave some detail about what he said, including the fact that Peterson's Twitter account was suspended following those tweets about Paige. He said that they don't need to decide if those comments are hateful, which is why Twitter suspended his account. But he says, maybe he said what the panel said was that they were inflammatory and unprofessional. And he said, obviously, he admits that they are controversial. But in response, when asked about the tweets, Peterson has provided significant context, including to the panel, the college panel, and in a lengthy YouTube video explaining his comments. And the panel, Gourlay says, needed to engage with Peterson's explanation. Peterson views his comments about McKenney and about Paige as good faith participation in political debate. And in response, all the college did was just affix labels to them. And labels just simply plucked from the code of ethics without any further analysis. And just putting a label on someone's comments in the context that they've explained these comments, that's not same thing as giving an analysis. And but that's all that the college did. That's all this panel did. And he also had these comments. Peter Austin also had these comments about Jerry Butts. He called him a prick, and he made these comments about aesthetic beauty and this plus size swimsuit model. And Peterson's lawyer described what the college panel said about those comments. And they said cumulatively, those comments are degrading and demeaning. And these comments, Gourlay said, were actually a good faith discussion about standards of aesthetic beauty. It was a prominent conversation that was happening all over Twitter. And the comment to Gerald Butts was in the context of a heated exchange. They could be considered rude comments, both of them. But the panel at the college made no effort to try to reconcile the comments, even if they were rude, with Peterson's to be right to freedom of expression. What they did was just turn to harm analysis and merely announce that there were harms without explanation. And the harms were undermining trust in the profession, undermining trust in the college's ability to regulate, and undermining trust in Peterson's ability as a clinical psychologist. That they just concluded that the comments could cause moderate harm to the people they were directed at and at the broader community. But Gourlay says, why? Where is the evidence of this harm? He said that there isn't even a chain of reasoning, and the potential for causing offense is not enough. He cites the case of Ward, which is a Supreme Court case that we were involved in about offensive jokes made by a Quebec comedian. And the Supreme Court in that case said, just because someone takes offense doesn't even mean someone is harmed, and offense is not enough. There is no right not to be offended. Gourlay then looked at those 2020 comments that I mentioned earlier. Remember, Peterson had made some comments in 2020 about transgenderism, and the college as a whole, not about individual people. And the college investigated those comments and determined that, nothing was needed they didn't need to do anything. And Gourlay said, Peterson's lawyer said that those 2020 comments may have been, even to quote him, spicier. Those are his words. And the panel there didn't find a specific harm or reputational harm. So what changed? Why did the 2022 panel reach such a different conclusion? All we have here is an assessment that some people could be offended, and then a leap that there was harm. And he said that is not enough, especially when the charter rights are engaged. Gourlay said there are things that the panel could have said, But it's not for the court now to go back and try and fill in the record and try to patch the holes that the college panel left. They didn't make a finding even that the comments were discriminatory. So we can't even consider that. The court doesn't have that open to them to look into. Gourlay then turned to the line of reasoning that the college panel was not impugning the content of his comments, just the tone. And it's sort of this, it's not what you said, it's how you said it, which is, I think, a conversation all of us who have ever been in a relationship have had at some point. So what Gourlay said is tone is protected by 2B as well. It's basically inseparable from content. Just saying that Dr. Peterson can be taken to task for being rude or caustic isn't good enough unless they can actually show that tone is somehow undermining the core interests of the profession, which they don't do. Gourlay says that this focus on tone and content, this difference between the two, is just an after the fact justification for the failure of the college panel to do any analysis. And as I said, this is like a really interesting argument to me. I think it's reminiscent of these domestic arguments a lot of us have had in our life. It's not what you said, it's how you said it. Maybe you can say that to your spouse, but a regulator can't say that to you. So that was it for Peterson's lawyer. We then turned to the interveners. We were an intervener, and so was the Canadian Civil Liberties Association, and so was this newish group, the Association of Aggrieved Professionals. So the CCLA, they were represented by the law firm BLG. They made two submissions. First, the regulator can only regulate speech within the core mandate of the profession. And second, that there's a distinction between conduct and speech. And here we're dealing with speech, not conduct. The CCLA argued that there's something unique and special about speech that doesn't relate to conduct, and it's fundamental to democracy, and it receives constitutional, and that's why it receives constitutional protection. As I said, this was about speech, not conduct, and the CCLA argued that regulators only have authority in areas that are core to their mandate. Regulators must have authority over that speech only when it falls within a core regulatory function. If it doesn't fall within the regulator's function, it's just like everybody's speech, protected and not subject to any regulation. And the distinction between regulated and unregulated speech doesn't hinge on if the speech is controversial. The scope also doesn't depend on the notoriety of a particular individual. So Justice Chabas then asked, but in a regulated profession, you cede some of your freedom of expression. And the CCLA agreed, yes. And I agree as well. Yes, you do. You do cede some, but only as it relates to the profession. And the CCLA lawyer gave an example. She said, if I, as a lawyer, wore a hat that said fuck Trudeau to a protest, that's not within the regulator's scope. But if I wore it into court to make an argument, that's another matter. That would fall within the regulator's scope. She said, if as a lawyer, I said the earth is flat, there's nothing special about me being a lawyer that gives me any expertise about that. But if I said, as a lawyer, I give you this legal advice, that is speech, but it falls within the profession. So she said that there must be a distinction between the personal and professional lives of regulated professionals. Regulators can't just do anything they want and claim it's in the public interest. The CCLA position is outside the bounds of professional practice. Regulators should have no role in determining what speech is good or bad. And this is actually probably further than what the applicant, Dr. Peterson, argued for. But I appreciate this argument as a strong supporter of freedom of expression. So the next intervener was the Association of Aggrieved Professionals. And as I said, this is a newish association with a unique view. They represent members of almost all regulated health professions, as well as members of other professions like lawyers, accountants, and teachers. And they said that the decision today, or yesterday, I guess now, would have broad effect And hopefully the court could avoid creating a chilling effect, because the effect of the decision could have long-lasting and irreparable harm to regulated professionals, and a determination and it could actually affect the choice of people to go into a regulated profession. People might say, I don't want to go into the profession of nurse, doctor, lawyer, teacher, psychologist, because this regulator may monitor what I post on Facebook and Twitter and come after me and take away my livelihood. So Shaba said, isn't that speculative? Aren't you just assuming that people won't want to join these professions because of this? And the lawyer for this association said it's an inference that if you regulate people's private lives, it will create a chilling effect. And he said it's a reasonable inference. And the lawyer for this association said what they wanted to do with their intervention is assist the court in determining what conduct is within or without outside of a regulator's authority. And he said a lot of people have been struggling with that line and they want to describe it. And he said, personal beliefs and expression that don't incite violence or hatred don't cross that line and can't be a concern for regulators. The role of the regulator is to protect the public by determining if conduct is misconduct. And at the end of the day, unless it's unlawful speech, their lawyer argued that it doesn't cross that line. It can't be that everyday social behavior is subject to discipline. And Dr. Peterson's comments are removed from his role as psychologist, and he doesn't even practice anymore, so he can speak about anything he chooses. He pointed out that in the original anonymous complaints, one of the statements says, on Joe Rogan, Dr. Peterson gave a diatribe about everything. And he said, yeah, this is social commentary. It's about everything. And he is at liberty to speak about that. Next up was, as an intervener, was us, the Canadian Constitution Foundation. These were obviously my favorite arguments. And our lawyers were from the law firm Baker McKenzie, and they were amazing. We argued for something really practical. I think a framework for the court to actually use to reach the right conclusions. We argued that the court needs to look at if there's a nexus between the off-duty conduct and the regulator's mandate, and then build in freedom of expression at that stage. Only when you find a nexus and balance freedom of expression, then you can go on to the Dore analysis, which is that administrative law analysis I talked about at the beginning. And I like this argument because I think it actually gives the court a workable framework that they can apply. First, determine if there's a nexus between speech and the profession, and then at the same stage, consider the weight of the right to freedom of expression, and then you get to Dore and you consider whether the reasons are sufficient. While in this case, the reasons are also insufficient, I think you can actually have this decision quashed before you even get there. So to do this, to find if there's a nexus, you need to look at the factors around the off-duty conduct. That's not necessarily an easy task. People have private lives, but there needs to be that nexus. And one factor could be that Dr. Peterson described himself as a clinical psychologist, but in Strom, the nurse case, she also described herself as a nurse. So describing yourself as a member of that profession is not the only factor. That would just be one-dimensional. Strom identified herself as a nurse and then complained about her grandfather's care at a long-term care home. And the Court of Appeal looked at that nexus and also at the same time looked at her right to freedom of expression. She had a right, they found, to express her concerns over the care her loved one received. And the court found that the tribunal, the nurses regulator, failed to give enough or any weight to 2B, to the right to freedom of expression. And the court just we also then cite another case involving a teacher who called themselves a teacher and then had complaints about her own children's education and their teacher and their school, but she didn't use, the normal proper process that teachers are required to use. And the court looked back at that, and because she was subject to discipline, and the court looked back and they said, she's a teacher, but she's also a parent. And just because she's a teacher doesn't mean she must be disciplined for not using that process. We also cited the case of an accountant who leveraged her designation in a dispute with her building, like her condo building. And in that case, it wasn't just about her designation, it was about what she was doing with it. So the Strom case and these other cases, they make a good point. The value of Section 2B, freedom of expression, is so high that we say it must be dealt with at the first stage of the analysis, not just at the Dore stage, because it underpins our entire constitutional system. Then that concluded all the arguments in support of Dr. Peterson. We had our lunch break. I went to have a salad in the Path, which is the underground mall system in downtown Toronto. Hold on, I'm going to have some more water. So we came back, and in the later half of the afternoon, we heard from the lawyers for the College of Psychologists. They started with a brief overview of the decision ordering this professionalism training for Dr. Peterson. First, they said, Dr. Peterson's a registered member of the college, and he has chosen to remain so he gains the benefits of the profession. And in return, they said he's required to be subject to the jurisdiction of the college, subject to that legislative framework, and that he's required to abide by the standards of professional conduct and ethics. The college said Peterson has established a wide audience in social media. And what brings us here today is these comments made during a narrow time period on social media and podcasts. And they said that these comments were brought to the college's attention through both informal and formal complaints by people who viewed the comments as unprofessional. And the lawyers for the college said Peterson's comments were not thoughtful comments on difficult issues. They were just insults. They were just demeaning comments, including comments about a former client. And the college lawyers said that the decision ordering this professionalism training did give reasons. They disagreed with Peterson's lawyer. There weren't enough reasons. They said there were reasons about why the comments were relevant to the profession. And having considered the comments and their relationship to the profession, the college considered options on how to address their concerns, and they decided on an educational remedial program, and that this they thought would address the concerns they had. And it's that decision, the ordering of the educational program, that is before the court. And the college lawyers said that they did have other options open, but they concluded that this option would achieve their objective in the best way possible and keeping in mind their obligations as a regulator. And they said it did take into account the legal and contextual factors around the case, and it did take into account Dr. Peterson's charter rights. The college lawyers then turned to what they say the order for this training, this coaching of professionalism for Dr. Peterson. They say they want to talk about what it does and what it does not do. They said there's no finding of professional misconduct. There's no referral to discipline. That does not require Dr. Peterson to change his opinion on an issue. It doesn't limit his use of social media channels. It doesn't address what will happen in the future. And if Dr. Peterson makes other posts that come to the attention of the college, that will be treated separately. It will be a different process and a different decision. So here, Professor Chavez interjected to say, but it doesn't address what will happen to Dr. Peterson if he doesn't comply. And, you're presenting it as if this order for the training is entirely benign, but it's something, it does impact his freedom of expression. It even says so in that decision. And the lawyer for the College of Psychologists replied and said, yes, he is required to engage with a coach and communicate in a professional way, but that's a specific and narrow order. It undoubtedly requires him to submit to an education program. And if he doesn't, the regulator has options. These things can have consequences, no doubt, but it will be determined on its own merits in its own time. And the college concluded that the comments Peterson had made were degrading and demeaning, and they had professional concerns according to the standards that that they created and that existed before Peterson made these comments. And the lawyer for the college said that the obligation of the college is to protect the reputation of the profession, that they were not addressing him at large for all the things he's maybe said or spoken about. They were just concerned with particular comments. And the college argued, we've heard about how other things Dr. Peterson may have said and done came to the college or were dealt with differently. And they said this is not a fact-finding committee finding professional misconduct. They're just here raising a concern. This is just a first step. It's a remedial step. They also said the concerns that they raised, they said that it undermined public trust and their role is to protect public trust. They found the comments raised concern about him being able to function as a psychologist, but they didn't make a finding. They just found it raised concerns. And they said it doesn't matter if he isn't currently practicing or wasn't practicing when he made these comments, because as a member of the profession, he's entitled to practice. And they said, the college lawyer said that his comments may cause harm to people who they were directed at and at the broader community. And the college had this concern about whether the comments could impact others. The college lawyer argued that when the college investigative committee identified these concerns, they were firmly grounded in the college's published standards and codes of ethics. It wasn't a situation that had not been thought about before. It related to specific standards that the college had under their legislative mandate and that Peterson had advance notice about. So the college lawyer then pulled up these standards, these professional standards, which talk about requirements to take precautions in how public comments are made. For example, public comments need to be supported by the literature, but they also need to be consistent with professional standards and ethics that the college has created, and the comments cannot be degrading or demeaning. So they said this was not an issue of lack of notice. The college lawyer argued these are published standards, and it's an area where a professional body like the college, the regulator, they're entitled to deference. They are entitled to identify what ethics should apply to their members, and this grounds their concerns as objective. The college lawyer said, when you read the reasons, there is a chain of thinking. But the college lawyer acknowledged that the panel that ordered this training didn't explicitly say, now we will do the Dore balancing analysis. But she said, you can see a chain of reasoning, and that satisfies Dore. They looked at the comments, how they related to the profession, and they looked at the range of options available to them. They also considered a proposal Dr. Peterson had put forward as an alternative. This was a proposal that he could have his own team of people help him with his social media. This included his employees or friends or family members. But the college found that this proposal wasn't sufficient because it wasn't independent, wasn't accountable to the college, and it wasn't by people who had expertise on the professionalism and ethics standards. The college lawyer said that the college isn't required to choose the least restrictive option open to them, which in this case, I guess, could have been using Dr. Peterson's proposal or, I guess, doing nothing. But this is where Justice Chavez interjected. He said, how do we measure least restrictive or how restrictive this was? Peterson has been ordered to sit down with a coach for as long as it takes for the coach to write a report and say that he's satisfied. He has to pay for the coach each time. And, you're acting like it's no big deal, but we don't know how long it could go on, and has this threat over him of disciplinary action. The lawyer for the college said, well, this is how regulators resolve things on a regular basis. And Chavez said, well, normally that doesn't involve charter rights. This is about freedom of expression. It's not about record keeping. It's not about advertising. This is about charter rights. And the lawyer for the college said, it isn't in anyone's interest for coaching to turn into a lifelong debate. And Justice Chavez said, but it might. And on that, I mean, you're dealing with Dr. Peterson here. I think that it very well could. It very well could be. Um, so then the lawyer for the College of Psychologists turned to looking at whether a proportionate balance was achieved by this order, including the weighing of charter rights. So first, the college lawyer addressed whether public statements engage professional regulation at all. Is there a professional nexus? Then she turned to questions on comments and tone. And on nexus, the lawyer said Peterson's comments were brought to the attention of the college, and they were concerned because he was identifying himself as a clinical psychologist. It isn't just in his Twitter bio. It was explained. It was in the introduction on Joe Rogan. He stated it on Joe Rogan. And in his letter to the college, he said he's functioning as a clinical psychologist and professor in the broad social sphere, helping millions of people. So counsel for the lawyer for the College of Psychologists said Dr. Peterson's own statements say he regards what he's doing as the broad practice of psychology. The lawyer for the college then pulled up case law that we cited and started responding to some of the arguments that we made as an intervener, Canadian Constitution Foundation. One of the cases involved a TTC employee who was wearing his uniform while doing something. And the college said that this is what Dr. Peterson is doing when he identifies himself as a psychologist. He's putting on his uniform as a psychologist, putting on the mantle of the profession. The college lawyer also noted that we, the CCF, had argued in our factum that professionals can wear different hats, their personal or professional hat, and distinguished the Strom case, which we also cited, that nurse case. They said, well, we say he's a public intellectual. She said maybe, but that's not a regulated profession. These comments, the ones that he made and that are at issue here, do not contribute to intellectual debate. Now, in my opinion, that is a subjective question, but in any event, the lawyer then moved on to another different point and this is, I think, a really important part of their argument, a part that I fundamentally disagree with. So the lawyer for the college said not all speech is created equal, as it lies further from the core values of freedom of expression, like search for political and social truth. It receives unequal protection. As stated in Whatcott, which is a Supreme Court case about hate speech, and in Ward, which was a case about offensive jokes by a comedian, some speech forces other people to argue for their basic humanity and social standing and leaves them in a position where their ability to participate in debate is negatively affected. That speech, this lawyer for the College of Psychologists argues, is entitled to less protection. So Justice Chavez asked, how do we draw that line? There's no suggestion here that Dr. Peterson's speech was violating human rights law or criminal law. So to answer that question, the lawyer for the college turned to some of Peterson's comments and said that these are not valuable speech. In particular, Peterson's comments about Elliot Page or the swimsuit model. Counsel for the college said Dr. Peterson's comment is to make a personal comment about an actor, suggesting something sinful is happening, pride in that case, and also making harsh comments about Page's physician. And she said this is not contributing to thoughtful debate about healthcare. It's not even responding to a comment about healthcare. He was responding to a comment about a character on TV. And even the comment on the physician, where he said Page's criminal physician removed her breasts or his breasts. Please don't cancel me for continuing to use the wrong pronouns. This Elliot Page. I really struggle to keep it all straight. But he said this Page's physician who removed Page's breasts is criminal. And this lawyer for the college said the code of ethics for psychologists requires them to be respectful of the expertise of others. The college said that this is of very little expressive value. It is just an insult. Then the lawyer for the College of Psychologists turned to Peterson's comments on McKinney and Butts and the Sports Illustrated swimsuit model, this plus size model, and said, the college doesn't even need to give an explanation for why these comments are demeaning. They're just demeaning on their face. They're just insults. Then the lawyer for the college turned to tone. I find the tone argument, as I said, interesting. And she said that the comments, the college found that the tone is unhelpful, non-valuable speech, and therefore not worthy of protection under the charter. On tone, Justice Chavez said, and I agree, I've always had a problem with the term tone. It's so subjective. I wonder if Justice Chavez has had some of those same spousal conversations that I've had. In response, the college lawyer said, yeah, tone is amorphous, but they grounded their concerns on tone, the college's concerns on Peterson's tone, in the standards of professional conduct and ethics. There's no way to frame that criminal physician tweet other than to say it's degrading and demeaning. So Chavez said, so degrading and demeaning, what's that mean? Is it just one of these, I know it when I see it? And the lawyer said, it's difficult to give reasons for something that's obvious. I'm not sure what else needs to be said. These comments were degrading and demeaning. So Peterson's lawyer had a lot to say about all of this in reply. Gourlay, who gave the reply, responded to say, on saying that Peterson's speech is of little value, this is just always the argument that the government makes for limiting speech. They always say, look at this speech. It was so awful. It doesn't even deserve protection. But freedom of expression isn't needed to protect popular speech. Speech that can offend is not at the periphery of protection. And when it engages on political and social issues, it's actually at the core, even if the tone is caustic. And we can't lose sight of that. Gourlay said that Section 2B of the Charter is engaged. It's core to 2B. And ever since the case of Irwin Toy, which is one of the early Section 2B cases, a meaningful burden on freedom of expression is enough to engage it. And this is a meaningful burden. This order of retraining, of ameliorating speech, of improving tone, that is enough. Peterson's been told his speech is bad. Go to see a coach who will decide once it's that you've made it good. That is a meaningful burden on freedom of speech. Whether or not this was the least intrusive option, Gourlay, Peterson's lawyer, said the college has just skipped the whole stage. It assumes that there's a need at all to sanction, and there isn't. Gourlay said that lofty and general rules about professionalism and disrepute are not self-defining. In the broadest scope, the rules and ethics could take in just about anything. What degrading and demeaning and disrepute of the profession, and all of this can capture just about anything that offends. Rarely is something called demeaning if we agree with it. That's why an analysis is needed, and the reasons here lacked the analysis. The college spent very little in time engaging with reasons, and this is now supplementing what the lawyers for the college are doing, are supplementing those reasons. And that approach died in the Vavilov case. This court would fall into a big error if it were to allow for the supplementing of reasons when the reasons given in the lower decision, which was the order for this special training, if they were insufficient, that's the end of it. He said that the lawyers for the college didn't engage in the analysis by the tribunal that ordered this training because there was no analysis to engage in. Very briefly, there were two interveners in support of the college's position. One of them was the College of Physicians, whose submissions were basically a lengthy list of cases involving sanctions against physicians. And then there was the advocacy group Egal and Trans Justice, which their submissions were largely policy driven about trans rights, and also about they kind of made an attempt to broaden the scope of the hearing yesterday into discrimination and Section 15, the Charter Right to Equality, and against discrimination. In my view, the Supreme Court has made it very clear that that is not your role as an intervener. It's very important as an intervener not to stick to the core of the dispute at hand and not add new issues. You cannot add new issues. So that was what happened at the hearing yesterday. This was a really long broadcast, a really long summary. I hope that I wanted to give a lot of detail because unlike some of the other proceedings where I've done live streams, there was no way you could watch this unless you were there in the room, and there wasn't space for a lot of us. So I'm sorry it was so long. I hope you appreciate me taking the time to give you such a detailed summary. This is such an important case. It's really important for professionals. We are all entitled to our private lives, not just those of us in regulated professionals, in regulated professions, but all of us who have jobs. We're not on the clock all the time. And we need to really closely guard against attempts by activists to sanction private speech when they just disagree with it. So I hope you guys enjoyed this broadcast. If you want to stay up to date about this case and about all our other cases, you can subscribe to the channel, like our videos, ring the notification bell. That way you'll get all of our updates. And thanks everybody for watching. There's a lot of you who are watching this. I'm just going through some of the comments. When will a decision be released? Not for a while. It typically takes 6 months or so to get a decision. So I'm not sure, maybe about that amount of time. But yeah, thanks everyone. Thanks for watching. So subscribe, sign up to our email. And if you want to donate to support the costs associated with this case, you can visit the ccf.ca/donate. All right, thanks everyone. And don't forget, share this with someone who you think might enjoy it. Okay, bye-bye.